Cool. Okay, your question. Well, basically, to put it very basically, tenants have rights to cancel lease agreements, and we speak about this all the time. Tenants are entitled to cancel early. It frustrates landlords beyond belief, but it is a right that's entrenched in our law. Under what circumstances does a landlord, can a landlord cancel a lease agreement before its expiry date? And I'm not referring to breaches here, just normal termination. I no longer want to rent out this property. Under what circumstances can a landlord do that?
Perfect. So what we're going to talk about today is Section 405C of the Rental Housing Act. It's a really important provision that's often not taken account of, okay? But it is something that is available to parties in circumstances where there is some sort of intention that a lease agreement can terminate in a specific circumstance. Okay, so Section 45C of the Rental Housing Act essentially says that the landlord's rights against the tenants include their right to terminate the lease agreement, okay, in respect of a rental housing property. But there are two conditions for the landlord to have this ability. The first is that whatever that right to terminate the lease agreement is, it cannot constitute what would be deemed to be an unfair practice in the circumstances. Okay, so in other words, again, what an unfair practice is, okay, is really a matter of interpretation in the circumstances. There's no defined list of this is an unfair practice, and so we have guidelines on what might be an unfair practice in the circumstances, but you do have to be very careful about what constitutes an unfair practice and what that may or may not mean in the circumstances. But that is the first element. And the second element of Section 45C is that whatever this triggering event is for the termination of the agreement, it must be specified within the lease agreement. Okay, and by virtue of the fact that the legislation says that it must be specified, this also has an element of requirement that this has got to be a written lease in the circumstances. Okay, so if you have agreed to a specific termination event, which is not an unfair practice and is specified in the lease agreement, that may be an ability for the parties to terminate the lease agreement early in the circumstances. Now, how does this practically work within our law? There is a common example which is contained within the TPN lease agreement, okay, which has been written into the lease agreement, and that is a circumstance where either the landlord, in other words, the owner of the property, either wants to take occupation of the premises themselves, or they are in a position where they want to sell the property in the circumstances. That is what we've included in the TPN lease agreement as two circumstances which we believe will not be amount to unfair practice. Okay, and we've done terminations on those bases before. Okay, and they've been the courts have accepted those particular grounds. But as I say, these are circumstances where the fact that the landlord wants to terminate the lease agreement would not constitute an unfair practice. So this can't, devolve into some sort of random circumstance. I can terminate at any point that I want because I want to. There's very specific requirements. And secondly, the parties have very specifically agreed that in the event that this happens, there will be the ability for the parties to vacate. So the question that came in today essentially was someone who is in the process of divorce, and unfortunately they are therefore looking to move out of their matrimonial home, and they have a property which they are currently renting, and they are asking the question, can I give my tenant notice because I want to move into the property in the circumstances? And the answer therefore is, well, that will depend now entirely on the lease agreement that you have with your particular tenant. Okay, so if you do have a lease agreement in place with your tenant, and this lease agreement has a clause which says, look, in the event that I need to move into my own property for whatever reason, and I'm going to take occupation of that property myself, I can give you a termination, and you must set out exactly what the terms are. So I can give you a month's notice, 2 months' notice, 3 months' notice, or whatever the case is. It is then possible in those circumstances. Another warning, because I have had clients, unfortunately, who do this, where they seek to use this particular a clause like this, where you agree to mutual termination in a certain circumstance, but they don't actually intend to take occupation or sell the property in the circumstances. Please be very careful. If you do that, and there is every possibility that the tenant will turn around and go, you're not selling the property, you're not actually taking occupation of the premises, and accordingly, you've repudiated the agreement by your conduct. And so you can sit yourself in a situation where a tenant is perfectly entitled to damages against you for the balance of the lease agreement because you have terminated it, which in a way that is actually a repudiation of the lease agreement. So please be very careful. I know we often talk about how frustrating it is to get tenants out, or the processes and having to follow the law to do it. Yes, absolutely. It is frustrating. It is timely. It is often costly, but it is something that you are going to have to go through if you don't want to risk repudiation and a situation where you actually are liable for damages in the circumstances. But again, Section 45C, if you guys have agreed in writing and it doesn't constitute an unfair practice, you may well have a situation where you can terminate a lease agreement early.
Awesome. Thanks so much, Nick.
Perfect. Thank you, Bruno, and we will see you next week.
Yeah, great. Thanks. Have a great one.
Yes.